Is Smith & Wesson supporting the Mexican cartel? Are guns now allowed again on playgrounds in New Mexico? All of this and more on today's 2A Roundup. Hello everyone, my name is attorney Rachel Moss and I am here with attorney Emma Wittmann, and we are here with another episode of 2A Roundup. Today we're really excited. We have a good episode for you. We have a mix of state and federal updates, and we also have some updates on some cases we've previously talked about on 2A Roundup. So today Emma's going to kick us off.
All right. Hey, how's everyone doing today? We have some good updates for you, as Rachel was saying. So we're going to start off with a bill that has been proposed. It is called the National Constitutional Carry Act. It was proposed by Republican Thomas Massie. This bill was actually introduced back in September of 2024, and he posted online urging Congress to support this bill in December. So what the act states is that citizens should be able to carry in public, and it is saying that states should not be able to enact any gun regulations that would go against the Second Amendment, the 14th Amendment, and of course citing to some of our favorite cases to talk about, such as Bruin, Heller, McDonald, all of those cases. So what this bill is hoping to do, if it gets passed through Congress, is to allow all citizens nationwide to carry in public.
I think this is really exciting, and I know a lot of people have been wanting this. It seems like Massie's really carrying out what Trump has, promised the American people that he's trying to accomplish in his first term. It is really interesting to see how this bill is going to travel through the House. I do think this type of bill is well supported by the recent Supreme Court jurisprudence that we've seen in decisions like Bruin. When we really consider what Bruin is instructing people in terms of what is an unconstitutional versus a constitutional gun law, this is something that seems like a long time coming when considering what the Supreme Court has been deciding in recent years.
Absolutely. And if you guys missed our November episode, we gave a brief overview of how a bill makes its way through the process of being passed. So check that out if you missed it and you need some more information. But we talked about it in the context of what Trump has been proposing and what he was pushing if he were to be back in office, which we now know he is. And it's very similar. He wants to enact a nationwide concealed carry reciprocity. So we're seeing these nationwide pushes for 2A rights. And so it'll be interesting to see if either of these make it through Congress.
Yeah, I think it's too soon to see. It looks like knowing that we have a Republican Congress now, I think it is more likely that this bill is going to have a lot of support. And it'll be interesting to see if there's any Republicans that aren't in support of this bill. I could see there being Democrats in support of this bill, but I'm expecting most will probably be against something like this. So it's too soon to see. Also, the bill is in its early stages, so I imagine it's going to get modified as it's considered by different committees in Congress. So there's probably going to be different changes made, maybe things added to the bill that we don't really want, maybe things taken away that weaken the bill for us. So I will be really interested to see what the final product of this bill looks like and if it really ends up getting much movement in Congress.
Yeah, absolutely. And we'll definitely have some fun updates throughout this year for you guys as we watch these progress. Like you were saying, it's probably not going to be a quick overnight process, but we'll keep an eye on it and keep you guys updated.
That's government for you.
We have another interesting case for you guys. It is Smith & Wesson versus the United States of Mexico. And Mexico is alleging that Smith & Wesson is marketing to the cartel in Mexico, such that they are marketing firearms to be military-style weapons, which is enticing to the cartel. And therefore, the cartel are specifically buying up certain Smith & Wesson firearms to use against the government in Mexico. So this case has been going on, started out at the lower courts, and then it was heard at the Court of Appeals in the First Circuit. And we need to dive into a little bit of background so you understand what they are arguing. So want to direct everyone's attention to the Protection Act, which says that firearm manufacturers should not be liable for the harms that third-party criminals cause when using firearms illegally. Now, there is an exception, and that's what we see the circuit court basing its decision on and saying that the exception actually applies. And that says suits are allowed against companies who knowingly violate firearm laws and is the proximate cause of the harm. And so right now this case is set for oral argument on March 4th, 2025 at the Supreme Court. So what Mexico is wanting is action by Smith & Wesson to actually stop selling these military-style weapons unless it's to military only. As you can imagine, Smith & Wesson is not happy with this for a multitude of reasons. Mexico is saying that not their biggest point, but that they can easily change the serial numbers on their firearms, and also their marketing practices are making it far too enticing for the cartel to want to purchase these AR-15s and other military-style weapons. Now, the AR-15 is actually the most popular gun for Americans to purchase right now. So that would definitely hurt Smith & Wesson's business. What I want to talk about today, though, is actually what the U.S. House of Republicans is doing and getting involved in this case. They have submitted an amicus brief in support of Smith & Wesson. So they are raising several issues with how the lower courts have currently ruled in this matter. One of the big issues that they take is the separation of powers. They're saying that Congress holds the authority and discretion to enact regulations for firearms and policies such as the one that we just talked about, that Protection Act. And if we now allow the judiciary to overrule what Congress has put in place, there's a separation of powers issue. They're also raising the concern that we are going to allow foreign governments to utilize our court system to get rid of gun laws or impose certain regulations and cut Congress completely out of the equation here. And I think they have very, valuable insight and very valid concerns.
Right. I mean, my first reaction when you're reading off the summary here is all good points. Those are all really good things people should be taking into account. And I think nowadays people really do have that fear of foreign governments meddling in United States politics. And this is an example, like you said, where here Mexico's trying to use our court system against us to potentially impose stricter gun regulations. And really, it calls into question are they using Smith & Wesson as kind of an excuse to modify something else? Is the cartel excuse really just a guise just to get at our gun laws in general? It could be either way. We don't know. But there is that concern. And I guess my first reaction when I think of the reasoning that Smith & Wesson is marketing is so enticing to the cartel, it just seems like such a stretch to me, because it seems like Smith & Wesson is just doing a good job highlighting the features of what they sell, and they should be allowed to be honest about what they're selling and be able to market it accurately to people. And just because the cartel recognizes it's a good weapon, that's not Smith & Wesson's fault. I think there's always going to be bad guys out there, and bad guys will always be trying to get a hold of guns. But if you regulate the ARs here, there's just going to be a new weapon in its place. We've talked about this before, that we see, mass killings with things like knives, with swords out there, with cars, vehicles, things like that. And so just because they're targeting this one weapon that apparently the cartel loves so much doesn't mean that getting rid of this weapon or regulating this weapon is going to solve the issue with the cartel.
Well, and I'm always going to take issue with putting in place regulations that harm the law-abiding citizens of our country because other individuals aren't acting responsibly. They're using products for illegal purposes. Those individuals are going to continue doing those things, whether there's a regulation in place or not. We shouldn't be taking away the rights and the privileges of the law-abiding citizens because individuals are using products criminally. They're going to probably continue to do that no matter what we put in place. So why take away the rights of those that are using them properly?
That's great. I think that's an excellent point, that this case is really about protecting the average American's rights. When it comes down to it, there seems like there's a lot of other issues that are kind of clouding what it's really about until you get to that amicus brief where it really highlights what's at stake here with this decision.
And I think it adds a whole nother layer of interest when we're talking about a different country coming in and trying to add regulations to our country based on actions happening from the cartels in their country, right? And it does become potentially dangerous if the courts are ruling in favor of Mexico and their concerns, or who knows what country is going to come in and ask for different regulations next. How much are our businesses and local gun manufacturers going to be regulated or limited to the point where they can't operate anymore? So definitely a concern of, where this could lead if it's upheld.
Very true. So you said the next step is oral argument coming up, right?
Yes. So Supreme Court's going to be hearing oral arguments on March 4th of this year. So we will wait to see how they decide to rule on this.
I'm excited. I'm going to place an early bet that Thomas is going to write the decision.
I think that would be fair.
Just wanting to call it. You heard it here first. But okay, everyone. So speaking of the Supreme Court, we're going to be talking about a case that is on remand from the Supreme Court of the United States. So you have heard us probably throw around this case name in the past, Range versus Lombardo. So Range versus Lombardo has a really interesting procedural history. What this case comes down to is an individual named Range, and he was convicted in 1995 of making a false statement to obtain food stamps. So he was sentenced to 3 years probation for this offense. He has no other major criminal history, but his conviction precludes him from owning or possessing a firearm because of United States statute. So Range had attempted to purchase some firearms in the past, and he was rejected. And eventually he learned it was because of United States statute 922G1. And he eventually decided to sue, arguing that this statute violated the Second Amendment. And he requested that there would be an injunction put in place prohibiting the United States from enforcing this law against him. And so he was saying that this law was unconstitutional as applied to him. So in 2020, he sued in the United States District Court in the Eastern District of Pennsylvania, seeking that injunction. He argued but for 922G1, he would be able to purchase a gun for self-defense. So after he filed this lawsuit, both parties moved for summary judgment. And the district court granted the government's motion for summary judgment. And they held that because his crime was so serious, it is enough to deprive him of his Second Amendment rights. Again, even though this offense was nonviolent, did not involve a gun, anything like that, it was just making a false statement to obtain food stamps. So Range timely appealed the case, but in the meantime, one of our other favorite cases, Bruin, was decided by the United States Supreme Court. And they thought, Bruin might just be relevant to this case. So they filed some supplemental briefs, but ultimately the Third Circuit affirmed the finding that the government met their burden to show that 922G1 reflects the historical tradition of firearm regulation. And that's the Bruin standard. Bruin really looks at, is it in our nation's history that we would have such a regulation? So they used that Bruin standard to affirm their previous decision, and they found that Range was outside of the class of people protected by the Second Amendment. However, Range decided to petition for a rehearing. His initial hearing was heard by a panel of the Third Circuit, not the full slate of Third Circuit judges. So you're allowed to petition for a rehearing, what's called en banc, so with all the judges on the court. So he got that rehearing, and he was successful. So the en banc court ended up reversing and remanding this decision, ordering the district court to enter a judgment for Range, finding that he is one of the people protected by the Second Amendment, because there's not a history of disarming people in our nation's tradition that are like Range. So then the government decided to petition the United States Supreme Court. And then another one of our favorite cases came out, Rahimi. So you can see this case was going on for a while because Bruin had time to come out, Rahimi had time to come out. Rahimi was decided, so the court decided to vacate the en banc decision made by the Third Circuit, and they remanded it back to the Third Circuit for further consideration. So that is where we are now. So I know that was a lot of procedural history.
But what an exciting time for Range to be making these challenges, right? I mean, it couldn't be better timing with the Bruin decision coming out. And then, of course, Rahimi, fantastic time to be this individual making this challenge and watching these other cases be decided at the Supreme Court.
Yeah, it really gave him a lot of the tools he needed. Bruin was definitely very helpful for his case. Rahimi arguably goes either way for him. I would encourage people to check out our previous video we discussed about Rahimi, because we go into a little bit about why Rahimi might be good for felons who might want to possess firearms, but also bad. So check out that video and see what we had to say about that. But it was really a great time because he had all this insight from the Supreme Court about what they thought. So the Third Circuit did a little summary of all of these cases when reaching their decision. They went back to the classic DC versus Heller, of course, first, because DC versus Heller was the Supreme Court decision that found that the Second Amendment guarantees an individual's right to keep and bear arms unconnected with militia service. Then they reviewed the Bruin standard that we just talked about. If the Second Amendment's plain text covers certain conduct, then the Constitution presumptively protects that conduct. So only if a firearm regulation is consistent with a nation's historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. So the question that they were addressing first here is whether Range is one of the people, so the people cited in the Second Amendment, who has the protection of the Second Amendment. So the government tried to argue that Range is not one of the people, and they tried to say that he would be one of the people that be historically excluded from protection of the Second Amendment. They said that it's only extended to the community of law-abiding, responsible citizens. And a lot of times people are citing to that law-abiding, responsible citizen language because it's mentioned in Heller. And really, this was the Supreme Court of the United States back in Heller, I think, just making a general statement. It wasn't supposed to be gospel that is what the Second Amendment is supposed to apply to, because criminal histories weren't at issue in Heller or Bruin. So they weren't saying that law-abiding, responsible citizens are the only people allowed to have the Second Amendment. They were just saying in Heller, in Bruin, those people were responsible, law-abiding citizens. It wasn't supposed to be exclusive of others. So the Third Circuit makes this point here, and then they get into the fact that the term "the people" is actually used in other amendments. Of course, we know the First Amendment, we know the Fourth Amendment. The term "the people" is used in those amendments, and those amendments, as we know as criminal defense attorneys, the Fourth Amendment applies to whether or not you're a felon. And then in the same way, the First Amendment protects felons as well. So in those amendments, they're considered part of the people. So there's the argument, why wouldn't they be a part of the people in the Second Amendment as well?
Yeah, and to your point, the Rahimi case still doesn't address the issue that's being brought up in Range, right? Mm-hmm. Yes, they definitely walked back Bruin a step, and they did essentially, not even essentially, they did bless disarming certain felons temporarily. Mm-hmm. And so I think the key there is temporarily. But how is that going to be viewed at the Supreme Court? How are they going to answer what we're doing with these nonviolent felons like Range, right?
Exactly. And so that's what they're getting at here, is whether a nonviolent felon like Range falls into the people. And the government really was trying to argue that Range is not a part of the people. However, the court, going over these things we just discussed, the fact that the people applies to other amendments, that Heller isn't conclusive about what the people means, they found here Range is among the people. So their next question goes into whether the government can strip him of his right to keep and bear arms, and whether the state has shown that applying 922G1 to Range would be consistent with the nation's historical tradition of firearm regulation. And so here the court ultimately held that the state did not carry its burden in showing this because of a few things. So again, when they're looking at the historical analogs, they go back and look at a bunch of history. The state gets to throw out a bunch of arguments for why they think we have a historical tradition of this type of firearm regulation. The court again points out what Rahimi emphasized, that when we're talking about a historical analog, we're not looking for a historical twin. That's part of the reason why Rahimi came up to the Supreme Court. The Supreme Court really needed to make that point, that we're not looking for a one-to-one here. It just needs to be relevantly similar to laws. And again, the government really tries to rely on Heller here by saying, look at Heller, there's a long-standing prohibition on the possession of firearms by felons, because that's what is mentioned in Heller. The Supreme Court, when writing their decision, specifically noted Heller does nothing to disrupt some of our long-standing traditions, like the possession of firearms by felons. However, the Third Circuit here points out that the earliest version of 922 G1 back in 1938 only applied to violent criminals. It did not apply to nonviolent criminals, and it was only the version passed in 1961 that expanded it to nonviolent criminals. So here they're saying 1961, that's not some long-standing tradition when you're looking at the scope of American history. The government also tried to cite a status-based restriction, saying, look, the United States has had a history of disarming people of certain religions, of certain races, people that they saw as threats. Again, I always feel like that argument's pretty racist when they bring up, oh yeah, we used to love to disarm black people back in the day. So I think, again, that's not a good argument to cite to here, but the government was trying to make the point that we've had a tradition of disarming people that the government distrusts. However, the Third Circuit pointed out that these restrictions were for disarming people that the government saw as physically dangerous people. Again, violent people, not non-violent felons like range. They also brought up the classic argument the government loves to make that, hey, we used to punish people by death as well, so isn't death more severe? But again, the Third Circuit said, that was for certain crimes. Just because certain crimes were punishable by death doesn't mean all crimes were, and it's still not the same thing as disarming people. They pointed out in the founding era that a felon could acquire arms after completing their sentence and reintegrating in society. So in conclusion, again, the state failed to show principles underlying our nation's history of regulating firearms support depriving Range of his Second Amendment rights here. So the decision here is very narrow. It was an as-applied challenge that Range made, meaning that Range was arguing that this law was unconstitutional as applied to him specifically. So this decision applies to Range, but it really gives other people an argument if they want to get their firearm rights back as well. Because what this argument really shows here is that there's not a historical tradition in the United States of disarming nonviolent felons once they've completed their sentence. And that's what I think is really important here, that this decision by the Third Circuit is showing that, hey, there may be some room here to disarm people that are violent, but we really need to consider how it is unconstitutional to disarm nonviolent people in the United States.
Yeah, I'm happy for Range. I think this was a long-coming win that he deserved. I know he, like you said in the beginning of this, has gone through quite the twists and turns over the years making these challenges. So definitely happy for him. I really, as we've been following this, was hoping the Supreme Court would issue some type of ruling on this matter that would create some precedent for everyone who is similar to Range. We're not quite there yet, but I definitely anticipate there's going to be more individuals still citing to Range and still making similar challenges that are looking to get those rights restored that are nonviolent felons with the past.
I think it's coming someday soon here because really when you look at the historical tradition here, there really is not a historical tradition of disarming nonviolent felons. Again, I think there are some arguments to be made about violent individuals. There's still some room to argue either side on that aspect as well, but at least for non-violent individuals, it is so clear that it's not part of our nation's history, that if you do the time, if you serve your sentence, and if you're released, you should be allowed to obtain your firearm again. And I think it's really great, like you said, for Range, because when you look at his history here, he was convicted way back in 1995. So now in 2025, we're here 30 years later, and he's proven that he's a law-abiding individual. He hasn't reoffended, and he's never shown any indication towards violence. I'm glad that he is getting to finally exercise his Second Amendment right. So again, I think this is a great decision, but I am looking forward to what's inevitably going to come next as some of these cases work their way back up to the Supreme Court.
Absolutely.
And so that takes us to our last update today. We wanted to give you a little local update as well. So we're going to go to New Mexico today for our local update. Back in September of 2023, there was a public health order in New Mexico that went into effect banning firearms from being carried in public parks and playgrounds in Albuquerque. And the public health order went into effect because the governor was arguing that it was intended to slow gun violence in the metro area. Many people obviously viewed this as a violation of the Second Amendment. The governor was sued a lot for this. Eventually, the scope was narrowed to this public health order, but the governor has now claimed that the order did allow New Mexico to implement urgent and necessary safety measures to have a positive effect on public safety. So she made this announcement in October of 2024, basically saying they're not renewing this public health order, but basically trying to tout it as a major success in Albuquerque. She cited many victories in making this public statement, saying things like, oh, during this time that the public health order was in effect, we collected over 1,700 firearms through gun buybacks. There was a doubling of arrests of violent and gun-related crimes. There were fewer gunfire incidents in New Mexico, and thousands of free gun locks were distributed by the Department of Health. And so I'm sure a lot of you are catching on here, but what does any of this have to do with the public safety order? What does anything have to do with this health order that she put out? It seems like a lot of these things would have happened regardless of whether or not she banned firearms in such an unconstitutional manner.
Yeah, and she got a lot of pushback for releasing these statements and trying to tout it as a big success. And there was definitely a lot of push and pressure put on her saying, where's the correlation? Show us the numbers, the actual ties to what you've done here based on this. And as far as I know, up to date, she hasn't followed up with any type of statistic to support her position.
Yeah, exactly. Because when she said fewer gunfire incidents, I wasn't exaggerating. That's what she said. There were just fewer gunfire incidents. She didn't say there was like a number or a percentage decrease. So for all we know, maybe there were 2 less incidents in 2024 than there were in the year before. And how could you say it's related to this as well? And again, looking at something like the doubling of arrests related to gun crimes. Is that correlation, causation? There's no way to know here, because I could see a doubling of arrests because maybe now the state has more resources because of this ban, but also maybe crime increased. And despite the gun ban, we see that in other places when guns are banned, that crime will increase. So maybe they had to arrest more people. We don't know what it is. So she's making all of these statements like it's because of her gun ban, but we really don't know that. So I think the governor definitely went too far with her statement here. Overall, I guess I'm glad that this public safety order is not being renewed. It seems very unconstitutional, but I'm really sad that it was in place at all to begin with, because I think we've seen this trend, and I think people are rightfully worried that certain government agencies are going to use public health orders and public health agencies as a tool to regulate firearms. And it just leaves me with a bad taste in my mouth to think that we're going to be trying to regulate firearms as a public health issue in this country.
Yeah, I absolutely agree with your position on that. It doesn't seem like that should be the proper avenue that they're utilizing.
Exactly. So I'm glad it went away, but I think it's something we have to keep an eye out in New Mexico, particularly because now there's a standard for it, but all across the United States as well. So with that, I think that takes us to the end of today's 2A Roundup. Thank you everyone so much for tuning in today. If you want to know a little bit more about us and our law firm, you can check us out on attorneysforfreedom.com. You can get to know our team and get to know a little bit about what types of cases we take. You can also check us out on attorneysonretainer.us. Attorneys on Retainer is a self-defense protection program where if you sign up and you are in a self-defense incident, your legal fees will be covered. So check that out. Learn all about it there at attorneysonretainer.us.
And if you like this video, you guys know what to do. Like, comment, share, subscribe. Until next time, this has been the 2A Roundup. Cheers.
Cheers.